Okay, nothing in this video is meant to be legal advice. This is a free video. Understand sometimes you get what you are paying for. In Illinois, if you have been ticketed for a DUI, which would include alcohol and other drugs, well, it is the instinct of many people to say, oh, today is August 1st. I got arrested and ticketed for driving under the influence. My first court date is September 3rd. I get paid 2 other times between now and then. I'm going to look at an attorney after I get paid. I don't want to go into debt. Maybe I'll be able to retain them my second time. That is the worst attitude you can have if you get a DUI. In short, there are very time-specific deadlines in Illinois after getting a DUI. There are 2 cases that you have, arguably 3, depending on if your car was towed and where it was towed to. But one of the cases involves your driver's license. It's a civil case. That case, your license will be revoked 46 days. I'm sorry, your license will be suspended. I really do need to get better editing software. Your license will be suspended 46 days after the date of arrest. You only have 90 days to challenge it from the date of the arrest. And if you challenge this early enough, let's say within the first 2 weeks after getting the ticket, depends on the county, depends on the prosecutor, depends on your driving history. I've had many clients that because of that, we file a request to have a petition to rescind statutory summary suspension, basically just a hearing for your civil case. If the hearing is not provided within 30 days or the first court date, whichever is later, then it is an automatic reversal of that suspension, meaning you will automatically win. So a lot of times you file a petition to rescind and then we go to the first court date, the officer's not there. Police officer has something else going on. Or I've had it times before where the first court date was in the wintertime and then the courts were closed because of inclement weather. Well, if it is a motion because of the state, the prosecutor, or the court, the judge, if it is one of those 2 that are the reason that it takes longer than 30 days or the first court date, then it is automatic that you will get your license back, then that the suspension will get reversed. So that is the most important reason why you should not sit around and mope after you've been given a DUI. Get on the phone, call good DUI attorneys like myself, call other DUI attorneys, and then they can also advise you about your towing case as well. A lot of times a towing case, you only have 7 days, 14 days, 30 days to even appeal it. In the city of Chicago, the fees are incredibly punitive, $2,000 and $3,000 plus the actual cost of towing and storage. And additionally, it's good while you get a DUI attorney early for that civil case, for the statutory summary suspension hearing. It's also good then to get the subpoenas out for all the video and audio and everything for the police, because a lot of times this audio and video, they get destroyed after 21 days, 14 days. Depends on the municipality, depends on the department. A lot of times depends on the people who are there. And there is, there's a lot of things that can be discovered about what really happened. And then if the police department is not providing it, then there is a basis to argue why certain evidence should be suppressed. But you cannot the longer you wait to send out those subpoenas, the more difficult of an argument you're going to have to make. So I've seen it before one time where a police department said they only keep certain videos and audios for 7 days. That is a little extreme, but I've seen it more often 21 days, 30 days, 14, even 14 days a few times. So, if you get nothing out of this video, if you get a DUI, and I'm really saying this to first-time DUI offenders, maybe if you got a DUI 30 years ago, 40 years ago, and then you got another one, maybe then this could apply to you. But if you've been through this before, you probably have a good enough knowledge base. If you've just got a DUI in Illinois and you're in a really bummed out mood, and like a lot of people, you're going to have this lethargy, this depression, this sort of, I'm going to lay around for a few weeks, no one's going to know about this, and I'll start moving on it here after I get a paycheck or two under my belt. That is the worst thing you can do for your Illinois DUI. You have to get moving on it. You get moving on it quickly, and one of the biggest tools, frankly, to help you with your civil case and indirectly with your criminal case is that is demanding a petition to rescind statutory summary suspension, because with it you demand a hearing within 30 days. You are entitled to the hearing, and if you don't have it, then it's an automatic. Then you automatically win. So do not wait around for the first court date, and the longer you wait, the worse it will be. I've had some clients come to me after 90 days after their arrest, and then they get very disappointed because I tell them I cannot even file a petition to rescind because you've waited longer than 90 days, and now you just have to deal with your suspension, and we can help get it reinstated later. So, okay, this is really basic, but give me a call. Look up DUI attorneys. Start giving them a call. But do not sit on your hands, and do not think this is something that the longer you wait for, time is not on your side. So, get moving sooner rather than later, and you will get a more favorable outcome for your case, all else being equal. So, or you should get a more favorable outcome. So, okay, no more out of me.